True bill of indictment. In the name and by authority of the state of Texas, grand jury of Bexar County, state of Texas, duly organized and paneled and sworn as such at the January term, AD 2024, of the 186th Judicial District Court of said county, in said court at said term, do present in and to said court, then in the county and state aforesaid and anterior to the presentment of this indictment. Count one. On or about the 21st day of October 2023, Darren Johnson, hereinafter referred to as defendant, did use and exhibit a deadly weapon, namely a motor vehicle, that in the manner of its use and intended use was capable of causing death and serious bodily injury. And defendant did intentionally, knowingly, and recklessly cause bodily injury to Mark Wayne Clanton, hereinafter referred to as complainant, by driving said deadly weapon at and in the direction of the complainant. Count two. On or about the 21st day of October 2023, Darren Johnson, hereinafter referred to as defendant, did intentionally and knowingly cause bodily injury to Mark Wayne Clanton, an individual who was 65 years of age or older, by hitting the complainant with a motor vehicle against the peace and dignity of the state, signed by the foreman of the grand jury.
All right, to that, how do you plead?
Not guilty, Your Honor.
All right, thank you. You may be seated. State, do you have any opening statements?
Yes, Your Honor. Flairwood Drive is an ordinary street located in North Bexar County, Texas. You're going to hear testimony that on October 21st of 2023, that street was not so ordinary on that day. You'll hear testimony that the complainant in this case was Mark Wayne Clanton. He has lived on Flairwood Drive for almost 20 years. His next door neighbor is the defendant, Darren Johnson. Now, on the date of the offense, Mark Clanton put his trash bins in front of his mailbox, and they were there for trash pickup. And on this day, the defendant in this case, you'll see video of her driving her motor vehicle. She drives a Ford F-350, and it's white. And she pulls up the street and makes a U-turn in front of Mark Clanton's home. She proceeds to get off of her vehicle and move Mark Clanton's trash cans from in front of his mailbox to the other side of his home. Mark Clanton sees this and he goes outside to put his trash bins back where he had them. Now he grabs a trash bin and proceeds to start walking to place the trash cans back in front of his mailbox. And you'll see the defendant hurry up to get into the driver's side of her motor vehicle and accelerate, put her truck up on the curb, collide with the trash bin, and knock Mark Clanton over. You will hear the injuries that he sustained from that collision, and you will get to see photos of that as well. Now, you'll hear from the law enforcement in this case that conducted the investigation. You're going to hear from Officer Kyle Gavin. He was one of the officers that responded on the date of the offense. And you're going to hear that initially he wrote up the offense listing the defendant as a victim in the case. And he listed Mark Clanton as a suspect for obstructing a roadway. You're also going to hear evidence that that report and conclusion was not supported by law at all. Now, the case gets transferred to different detectives for follow-up, and they receive video evidence in the case. And when they review that evidence, they say, hey, obstruction was not a legally founded charge here. An aggravated assault has occurred. They conduct further investigation, reviewing videos, taking statements from witnesses, and that is how we end up here today. The defendant did commit the offense of aggravated assault with a deadly weapon, and she also committed the offense of injury to an elderly. You will hear testimony that Mark was 68 years of age on the day that this offense occurred. And at the end of this trial, we are confident that you will find the defendant guilty. Thank you.
All right, defense, do you have any opening statements?
Yes, Your Honor.
You may proceed.
Morning. This is a situation where my client lived next door to the Clantons. houses are very close together. There's a curb in front of the houses. There's two, I'm gonna call them trash cans, and I'm sure one was a mulch bin or recycle. The one that you're gonna see that's closest to my client's house is also a place where the curb goes down to the street level and goes back up. That occurs so that water can come out between the houses. On the date that this incident happened, it's on a Saturday. There's no trash pickup on a Saturday. Mr. Clanton goes out and puts empty trash cans out there, blocking her place to park. He knows she always parks there. She comes back from an event, she tries to park. She stops her car. You're gonna see that when she stops her car in that, and this is very hard to see from the video because the angle of the video, there's trees in the way, all kinds of things in the way. So what you're gonna find though is that she stops and the wheel of her car is at that point on the curb where it's closest to the ground, just barely. She stops the car, gets out, carefully moves the cans behind, puts them in front of the house, gets back in the car, starts moving forward, not accelerating, moving forward. This guy comes running out of his house, grabs the cans, comes out, almost jumps in front of the car. The officers on the scene, not just one, but all of them, they saw the video at the scene. And they determined that he was responsible. They wrote up the report that way, and they went over and chastised him for it. So we're gonna write you up for obstruction. You don't jump in front of a moving car. You just don't do that. Okay. Then, 11 days later, he gets photos taken of the alleged injuries. 11 days later. 11 days later. This detective gets involved. I'm not really sure what happens as far as his, what's going on with him. I just know that he changes the whole report. Now he says, well, she's responsible, aggravated assault with a deadly weapon. She must have had the mental intent to run this guy over, or at least injure him, which requires a mental culpability. There is no mental culpability in this case. There's no crime in this case. And we believe that's what the evidence will show. And at the end, we're going to ask you to find my client not guilty. Thank you.
All right, state, you may call your first witness.
The state calls Officer Kyle Gapin.
If you can raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear and the court reporter can hear. If you'll state your name for the record, please.
Kyle Gapin. Gapen.
All right, state, you may proceed.
Officer Gapin, how are you currently employed?
I'm employed as a peace officer with San Antonio Police Department.
And is that a certified peace officer?
Yes, ma'am.
How long have you been employed with San Antonio Police Department?
For almost 2 years.
Can you explain to the jury the training you underwent to become a law enforcement officer with San Antonio Police Department?
We went through a 9-month academy with double the state's required hours for license certification.
What type of things did you learn in the academy?
Traffic law, penal code, CCP, arrest search and seizure, and then tactics and shooting, driving.
Once you complete the academy, what is the next step in your training?
We go on a 3-month FTO period. So each month is at a different station with a different FTO. And if you progress to each, like phase 1, then you go to phase 2, phase 3, and then you have a 2-week period where you're evaluated without the assistance of an FTO.
And just so the jury is aware, does the FTO stand for Field Training Officer?
Yes.
And is that an officer that is more senior than the person that he's training?
Yes.
Okay, and so when you're in this FTO program, are you considered a probationary officer, commonly known as a probie?
Yes.
Okay. What is your current title and assignment with SAPD?
I am an officer and my assignment's on North B shift.
And as a officer, what are your duties?
To, protect and serve, patrol the area given, my districts and the service area.
Okay, when you say patrol, does that mean respond to calls for service where citizens are calling 911 for help?
Yes,
Okay. Now I want to turn your attention to October 21st of 2023. Were you employed as a police officer with the San Antonio Police Department on that day?
yes.
And about how long had you been on the force at that time?
As a licensed peace officer, less than 1 month.
Okay. And so were you in your probationary period at that time?
Yes.
All right. And what shift were you working on that day?
North daylight, north A shift.
And what hours does daylight run?
I think it's 6:30 to 1:30.
Okay. Were you in uniform on that day?
I was, yes.
And were you in a marked patrol unit?
Yes.
Okay. Did you respond to a call for service on that day?
Yes.
Did you write a report associated with that call?
Yes.
Would it help you refresh your memory if you were able to review a copy of that report?
Yes.
I'm showing you what has been marked for identification purposes as State's Exhibit number 1. Do you recognize this?
Yes.
Were you the author of that document?
Yes.
And is it a fair and accurate depiction of the report that you generated on October 21st, 2023?
Yes.
All right, you're able to refresh your memory. Please don't read from it. So can you please explain to the jury what address you responded to on October 21st of 2023?
It was 13903 Flairwood.
Is that located in San Antonio, Texas?
Yes.
And is that located in Bexar County, Texas?
Yes.
What type of location is that?
It's a residence.
Do you recall why you were dispatched to that residence?
It was an accident.
And is the SAPD case number associated with that call SAPD 23236613?
Yes.
Once you arrived on scene, who did you make contact with?
I believe I made contact with the defendant.
Okay. And can you just describe the scene that you observed upon arrival?
So there was a truck, garbage cans to the side of it, and then an individual that was on the ground. And then the defendant was back by her house. And we went to go because there was an officer that responded first. We talked with him and then we switched over to speak with the kind of exchange and go to the defendant.
Okay, what type of vehicle, or you said you saw a truck, is that correct?
Yes.
What type of truck was that?
It was a Ford pickup truck.
Do you recall what make and model it was?
It was a 350.
Okay. And so you make contact with the defendant, is that correct?
Yes.
All right, and then did you take statements from anybody else on scene?
Yes.
Who was that?
From the victim
Oh.
of this one.
And so in your report, who did you list as the victim in your report?
In my report, the defendant was the victim and the current victim of
Okay.
switched.
I'm gonna have you use names, so.
Okay.
In your investigation on scene, who did you determine to be the victim in your opinion?
Darren Johnson.
Okay, and who did you determine to be the suspect from the limited investigation that you did on scene?
I think his name was Clayton, Mr. Clayton.
Okay. And was there video evidence that you were able to observe on scene?
Yes.
Okay, and how did you view that video evidence?
Through a cell phone.
Through a cell phone?
Yes.
Okay, and what size was the screen?
I think it was an iPhone, so I don't know, 3x2. I don't really know the dimensions.
Okay. And then after taking all statements, what type of report did you generate?
I generated an obstruction of highway report.
Okay. And what was the reason that you did that?
I felt that after watching the video, Mr. Clayton had obstructed the Ms. Johnson from driving her vehicle.
Okay. What is the legal definition of obstruction?
To impede passage.
Impeded passageway and
Yes.
render it impassable, is that correct?
Yes.
All right, and so you've had an opportunity to view the video evidence again, correct?
Yes.
And in viewing that video evidence, was the passageway rendered impassable?
No.
Okay,
Judge, I'm gonna object, that's a legal conclusion.
That'll be sustained.
May disregard.
Ladies and gentlemen, you're to disregard the last answer that was given by the witness. Does everyone understand? Thank you.
in watching the video evidence, were there other areas of the street where vehicles could pass?
Yes.
All right, so, excuse me, to the witness?
That's okay, Judge.
No, I just want to explain something, because I know sometimes people are not used to testifying. If you ever see any party stand up, don't answer the question because they're about to make an objection.
Yes, ma'am.
All right,
Yes,
you may
ma'am.
proceed, state.
And the reason that you took this report, is it because you were trying to gain
Leading judge.
experience?
All right, let me hear the question and then I'll hear your objection.
What was the reason that you decided to take the report writing responsibilities as a probationary officer?
To gain experience for the call, we were assigned to that call in order to satisfy training objectives for a motor vehicle striking a pedestrian.
We passed the witness, Your Honor.
All right, defense?
Good morning, officer. My name is Robert Porter. I'm gonna ask you a few questions. Can you hear me? Okay. I'm gonna ask you a few questions. If you don't understand them, just say, I don't understand them, okay? Now, probationary officer, you had already gone through a lot of training, is that right?
Yes, sir.
Now, let me ask you a couple of things. When you arrived on scene, you talked to the complainant, I guess, well, you talked to both parties, is that right?
Yes.
Nobody else was out there on the scene when this happened, is that right?
I don't think when the incident occurred.
When the incident occurred?
No, I don't believe anyone was out there, but people did come out to assist. There were several people around.
Okay. After the fact? Other people showed up after the fact, right?
To my knowledge, yes.
Okay. So when you were at the scene, you had an opportunity to view the scene, is that right?
Yes.
And being a rookie, I guess, and I don't mean to just downplay you, but being in the job, you took extra care because you're being judged on how you write reports, is that right?
Yes.
Okay. So being a good officer at that time, you watched the scene, looked at the scene, is that right?
Yes.
Okay. Now, would you agree with me that you also looked at the curb where the trash bins were placed?
Yes.
Okay. And you agree with me also that that curb isn't a raised curb throughout the whole thing. There's actually a dip in the curb that goes to street level and then they come up. Is that right?
I believe like at the driveway area, if that's where you're talking about.
Well, there's the driveway area and then there's the area right between the two houses. There's a dip, right?
I don't remember if there
You
was.
don't remember that?
No.
Judgment approach.
Yes.
So I'm going to show you what's been marked as defense exhibit number 1. Okay. Now you mentioned in your report. Well, let me ask you this. Do you recognize this photo?
Like the location in the photo?
Correct.
Yes. Yes.
Okay. Do you recognize that?
Yes.
Okay. Now, what does that alleged to have shown?
That there's a dip in the curb.
Okay. Now, is this picture the location where this happened?
In the general area, yes.
Okay. And you had mentioned the address?
Yes, this is, I believe, Mr. Clayton's address.
Okay. Has this been altered or amended from the date you were there in any way?
I don't believe so, no.
Okay. This time, Judge, we're gonna offer State's, the defense exhibit number 1, tendered to state for any objections.
No objection.
Right, defense exhibit number 1 is admitted without objection.
Okay, so you've agreed with me that there's that dip in the sidewalk. Now, this happened on a Saturday, is that right?
I'm unfamiliar with what day it was.
October 21st of 2023. Do you have a cell phone with you?
I do, yes.
Pick it up. Scroll through your calendar.
Judge, I'm gonna object to lack of personal knowledge and relevance.
All right, that will be overruled.
You can look up October 21st of 2023.
Yes, it is a Saturday.
Is there trash pickup on Saturdays?
I'm unfamiliar with that area. If,
There's no trash pickup on Sundays either, is that right?
again, I'm unfamiliar. I figured neighborhoods do it differently.
Are you aware of the city ordinance that says you're not supposed to be putting out your trash cans until within 24 hours of the date it's supposed to be picked up?
I was unaware of that, no.
Now, when you showed up, you're getting different versions of what happened, is that right?
Yes,
Okay. But you were actually able to watch a video of what happened, is that right?
yes,
Now, once you watch that video matched what Ms. Johnson was telling you, is that right?
for the most part, yes.
So let's kind of walk through it a little bit, is that right?
Okay.
Okay, so these bands were placed right at the edge of the one house and then right at the edge of Mrs. Johnson's house, is that right? Because they're neighbors.
Yes,
You can see Miss Johnson, let me ask you this, that pickup truck, it's a big old 350, is that right?
yes,
It's a big vehicle. You'd agree with me on that?
Yeah.
So she pulls up, right? And in order for her to go forward to go in front of her house, she gets out of her pickup and then moves the trash cans, is that right?
yes.
Now, these trash cans weren't moved to the other side of the property, they were actually moved into his driveway, isn't that right?
I don't know where they were moved. I just know that they were moved off of the roadway.
And at that point in time, all you're seeing is Miss Johnson, is that right?
Yes,
But then at that time, what you see it, if you look closely at that picture that I just showed you, that the pickup truck she had pulled in. Front tire was on this edge right here. Do you agree with me on that?
I don't know.
You don't remember?
I don't remember, no.
So what you did see though. And at the time you didn't know who it was, but you see a man moving quickly, grabbing a blue van and quickly moving toward that curve. Is that right?
Yes,
It was in a rush. It wasn't like I'm just kind of sauntering, right? And as he's doing this, that video also shows Ms. Johnson getting back into her truck. Is that right?
yes.
Is it generally a good idea when you're gonna pull out or go forward to check your blind spot?
Yes,
So what that video shows, it's a bang bang situation, isn't that right?
yes,
And in fact, what you see is the truck going forward. It wasn't racing forward, right?
it was not.
It was just pulling forward,
Yes,
right? But what you do see is Mr. Clayton, is that how you pronounce it? Clanton? You do see him coming very fast toward the front of the truck, right? With his dumpster.
yes,
And then you see the truck kind of go up.
yes,
What you don't see is the truck's tires turning.
correct.
They're going straight.
Yes,
Okay. And at that point in time, what you see is just a bang. She stops right away and then you see him fall down,
yes,
right? Okay. Now, in speaking with this, so once you saw that, have you reviewed that video before your testimony?
yes.
Okay. Can you tell from the video whether the pickup truck hit him or did it hit the dumpster?
Honestly, I don't know that. I mean,
We don't know,
Yeah.
right? We don't know. But what we do know is we see Miss Johnson get out of her truck right away, right? She walks around, sees him there, he's yelling, and she calls police. Right?
yes, I believe she was one. Yes.
You talked to everybody that day on the scene on the 21st of October. Is that right?
For the most part, yeah.
You watched that video on the 21st of October, correct?
Yes.
You viewed Mr. Clanton on the 21st of October. Is that right?
Yes.
You didn't see any injuries on him.
I did not. No.
Now, based on that, in fact, you looked at everything, and I'm not asking you to draw a legal conclusion, but you looked at everything, right?
Yes.
Okay, based on what you saw with just on the video, let's take away what everybody's editorialization is. Based on the video, what you saw was an obstruction. Is that right?
Yes.
Okay. And that obstruction was because you saw this gentleman going fast, trying to place it in front of a moving vehicle.
Yeah, or himself. Yeah.
Or himself,
Yeah.
right? Is that a safe thing to do?
No.
The smart thing to do?
No.
How many more officers showed up at the scene?
Including supervisors or just officers?
Well, let's just start with the officers. How many officers?
Okay. I think at least 4 others that were there besides me and my FTO.
And then you said other people showed up?
Yeah, there was one supervisor that showed up.
Okay. Who else showed up to the scene while you were there?
EMS showed up. Was there?
And EMS also showed up at that point in time?
Yes.
Do you remember if the EMS took him to the hospital?
They did not.
You weren't the only officer that viewed that video on the 21st of October, is that right?
Yes.
Who else viewed that?
My FTO.
For the jury's edification, FTO is field training officer?
Yeah, my field training officer.
Were you in the same car you riding with him?
Yes, sir.
You weren't discouraged by him to not write the obstruction.
Can you
In other words, he didn't say, no, don't write an obstruction.
I'm gonna object to hearsay based on what the officer is telling him.
All right, that objection will be sustained as to hearsay.
Okay. Needless to say, does your field training officer, does he review your reports?
Yes.
And after review, you never changed your report?
No.
Once you're done, because I guess you wrote the report because you're considered what's called the lead officer, is that right?
Yeah, so I took the call for training purposes that I would handle the call, be the handling officer.
So it's your responsibility, let me ask you this, between you and the detective, what are the responsibilities change?
Just me and any detective or
Okay, so
like in the general sense?
I'm sorry to interrupt you, let me clarify that a little
Yes,
bit.
sir.
So your duty that day was you went there, right? You viewed the scene. Would you agree with me, viewing the scene is extremely important?
Absolutely.
And so it's imperative that you go there to see what's going on.
Yes.
Okay. You talked to any potential witnesses. Okay.
Yes.
You looked at everybody.
Yes.
You looked at the evidence itself. Is that right?
Yes, I did.
Okay. You wrote your report, and that report, there's nowhere in there about an aggravated assault, right?
Correct.
Based on that, you passed the case off. Is that right?
Yes.
You said, who was the first officer on scene?
I believe his name was De Leon.
De Leon?
I think so.
You know if he wrote a report?
I don't know if he wrote a report or not.
Is it common that when officers show up at a scene, do they all write reports?
It depends on what happens on the scene.
Okay,
Some,
no, go ahead.
I was just gonna say, sometimes we're prompted to write reports. Sometimes if it's a certain level of an offense, or if it involves another officer, or if there's a use of force or something like that, all the officers on the scene, even if they didn't make contact with anyone, if they were just patrolling around, they would just indicate I did nothing, basically.
So let me ask you this.
Yes.
When you write your report, is that just your own personal knowledge, or do you take into consideration what all the other officers, if you all talked about it, decide to write your?
Yeah, it's a collective effort. Everyone's kind of working together.
So on the 21st of October, the collective effort of all the officers there, right? It was an obstruction case.
Well, between me and myself and my FTO, we were the kind of people we were interacting with. Yeah, that's what we concluded.
I'll pass it.
Any
State?
further questions?
All right, is this witness excused or subject for recall?
Excused by the state.
All right, you may step down. Please leave the exhibits and with the court reporter. All right, state, call your next witness.
State calls Officer J. DeLeon.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear. If you'll state your name for the record.
Officer Jesus de Leon.
All right, state, you may proceed.
Officer DeLeon,
How are you currently employed?
With the San Antonio Police Department?
Are you a certified peace officer?
Yes,
How long have you been employed with the San Antonio Police Department?
5 years.
Okay. And what kind of training did you undergo to become a police officer with SAPD?
During the training at the Police Academy, we were trained in the Code of Criminal Procedure, the Texas Penal Code, mechanics of arrest, scene management, firearms training, driving training.
And the training academy, is it about 9 months? Is that
Yes, that's correct.
after you complete the academy, what's the next step in training?
The next step is field training, which consists of being out in the field for several months, 1 month at a time with a training officer who is an experienced officer that has been on patrol for a number of years and has that certification. You'll be with that training officer 1 month at a time, learning how to handle the calls out in the field under their guidance.
Okay. What is your current title and assignment with SAPD?
I'm a patrol officer in the North District area.
What are your duties as a patrol officer in the north?
Handling a lot of the calls that were dispatched to, domestic disturbances, family violence, assaults, handling crash accidents, the highways, local roadways, patrolling around school districts, especially during school times, and doing on-site activities for things that we deem to be not right or suspicious.
Okay. Now back on October 21st of 2023, were you employed as a police officer with SAPD?
Yes,
And was your title and assignment the same as a patrol officer with the North Substation?
yes,
And were your duties the same as responding to calls for service?
yes,
Okay. And on that day, were you dispatched to a call for service?
yes.
Do you recall the SAPD case number associated with that call?
I do not recall it right at the moment.
When you respond to a call, can you explain to the jury what a key card is?
The key card is the information that becomes available on the screen computer that's in the patrol vehicle. It's where the information comes across for the address that we're going to and what the call is coded out as, meaning what type of call am I responding to? Is it an accident or an assault? And it has some details that may have been provided that will be relayed at the bottom of the screen, which shows maybe what is going on with victims or suspects or vehicles involved. And that provides us some information as we're driving to the scene.
Okay. So was there a key card associated with the case that we're here for today?
Yes,
Would it help to refresh and did you make entries on that key card on the day of?
yes,
would it help you refresh your memory if you were able to observe a copy of that?
Yes,
I'm showing you what's been marked as State's Exhibit number 2. Do you recognize this document?
yes,
Okay, and is that your name on the document?
yes,
And are those the entries that you made on the document?
yes,
And is this a fair and accurate depiction of the key card as it was on the date of the offense?
yes.
Okay, if you need to, you can refresh your memory, just please don't read from it. So can you tell me, is the SAPD case number associated with the call that you were dispatched to? SAPD 23-23-66-13.
Yes.
And when you were dispatched to the location, do you remember, were you first on scene or were there other officers there? Can you explain that to the jury?
I was the first officer to arrive on scene.
Okay. Can you please describe to the jury the scene that you encountered upon arrival?
Yes, when I arrived to the location, I exited my vehicle and I started walking towards the grassy area. I first observed a white truck that was parked curbside in front of the address. And male was laying on the grassy area adjacent to the curb. There were several people around him, maybe 5 people, 5 persons. And then there was a female that was standing several feet away from him. And I spoke with the person that was laying on the ground and then the female person that was standing up, trying to ascertain what had happened, and then keeping the persons separated that should have been kept separated.
Okay, and the location that you were dispatched to and the scene that you just described, was that located at 13903 Flairwood Drive?
Yes,
And is that located in Bexar County, Texas?
yes,
And what type of location is that?
it's a residential home.
Okay. And so you make contact with multiple people on scene, is that correct?
Yes.
Can you walk the jury through the people that you made contact with?
I made contact with the person laying on the ground who was Mark Clanton. And I made contact with the person that had been driving the truck, Darren Johnson. And I made contact with a person there who said he was a witness to what had occurred.
Do you recall that individual's name?
His name is Aaron Rodriguez.
Did other officers arrive on scene?
Yes,
And who ultimately took the responsibility of writing the report that day?
Officer Gapin was a probationary officer who had been out there maybe 2 weeks. I don't recall exactly. He was with his field training officer, which was Jesus Torres Rosado. And he informed me that he wanted the probationary writer to take the main point on the investigation.
Object on the basis of hearsay.
All right, that'll be overruled.
You can continue.
And from that point on, I informed the person I had been speaking with at that time, which was Darren Johnson, to speak with that officer, Officer Gapin.
Okay. In your interaction with the defendant, Darren, well, do you see Darren Johnson in the courtroom today?
Yes, I do.
Can you please point to her and identify her by an article of clothing?
She was wearing the gray blazer.
Thank you. And so can you describe her demeanor when you spoke with her?
When I spoke with her when I arrived, she seemed a little excited. She made some comments that made it seem to me that she wanted to be non-culpable of anything that had happened.
Wait, just 1 second. So whenever attorney stands, I need you to stop talking because they're raising an objection.
Yes.
All right, defense, what is your objection?
Well, my objection is he's making a comment about what my client said, and he's using the basis of saying she seemed a little excited, but this is hearsay.
All right, with regards to hearsay, that objection will be overruled.
I guess, Judge, can the parties approach very
Yes.
briefly? Officer DeLeon, were you wearing a body worn camera on the date of the offense?
Yes,
And did that capture your interaction with the defendant?
yes.
I'm gonna show you what's been marked as state's exhibit number 3. And I'm pulling the contents out of the envelope. Do you recognize this?
Yes,
What is it?
it's a disc from the video that I viewed earlier and initialed.
Okay, and so this is a copy of your body worn camera,
Yes,
and did you place your identifying marks on it so that you know this is the same thing that you've previously reviewed?
yes,
And is it a fair and accurate depiction of the scene as you observed it on the date of the offense?
yes.
And except to comply with legal rules, has it been altered in any way?
Not to my knowledge. No.
At this time, we offer state's exhibit number 3.
All right, state's exhibit 3 will be admitted over defense's objection.
Permission to publish, Your Honor.
Granted.
And so we see you kind of gesturing. I'm pausing the state's exhibit. As the first officer on scene, what are you doing when you're gesturing?
When I'm gesturing there, wanting to have the defendant step away from where the victim is at that time.
And why is that important? And
I want to keep the parties separated to keep anything from happening further. And at this point, I'm not 100% sure what's happened, so I'm still assessing. I want to get a statement from her, at least get some information while not being near the other party.
I'm playing state's exhibit number 3 at 1 minute and 40 seconds.
Okay, were you driving?
Yes, sir, he jumped in front of my vehicle.
Oh, did you driver's license?
Yes, sir.
You need to stand over here away from me. Yeah, I'm gonna tell you one more time, okay? I don't want to repeat myself, okay?
And so when you're telling the defendant, you know, not to give the statement at that time, is it important that all witnesses are not giving their statements in front of each other?
Yes,
And why is that?
it's important because they can hear each other and then they can take the information from each other's story.
And do you know the name of that witness that you're speaking to?
It's Aaron Rodriguez.
And what are we observing displayed on state's exhibit number 3, or what did we just observe?
Their SAFD arrived to the San Antonio Fire Department, and I let them know that the victim is laying on the other side of the truck, needs to be checked.
Did you observe them render aid to Mark Blanton?
Yes,
Okay, ma'am.
So I moved trash cans in front of my house, so I couldn't park. I
Okay.
moved them, and I didn't expect that he would jump out in front of my vehicle. When he knew I was trying to park there, he said, "You can't park here." I said, "It's street parking." You know, I was parking the carts, I bought groceries. He knew that, he jumped in front of the vehicle. You know, this is all staged, just like the other thing is.
Okay, where were they standing? Were they?
It was in front, so I couldn't park in front of my house.
And was it on this side of the
Yes, yes,
black or not?
yes. And it doesn't matter, it's street parking, I should be able to park there. I moved it, he said, "Don't move my trash cans, you can't park anywhere in front of the houses." I said, "It's street parking, my driveway's full, I wanna unload my groceries," and he jumped in front of the vehicle. They also have video. Huh? No, I'm not up on the curb, no, I stopped immediately when he jumped in front of the car. You know, you can see I was trying to park, he was crashing it down there, so I can't park. And when I moved, he tried to jump in front of my vehicle.
Carmen, whenever you start talking to the stop sign, I appreciate it.
Your Honor, at this time, the state offers state exhibit number 4 under Rule 803 and 902, and I'm tendering to defense first.
No objection, Your Honor.
All right, let me see state's exhibit number 4, so I can mark it. All right, State's Exhibit number 4 is admitted without objection. Granted.
All right, Officer DeLeon, can you see that? If you have trouble, you can turn around and look on the big screen. Is that? Can you see it on that screen, or you need to turn around?
I'll turn around.
Okay. Are you able to observe it on there?
Yes,
Okay. Can you tell me who is the patient that these records are associated with?
Mark Clayton,
Are you able to observe that?
yes.
Can you tell me the date of birth? And can you read from State's Exhibit? Can you read that first paragraph?
Judge,
Starting from here.
E40 arrived on scene to find a 78-year-old male lying down in yard complaining of right-sided knee pain. From being hit by vehicle, E40 began physical assessment and found patient was, and I don't know what the abbreviation stands for.
Okay.
LOC, DCP, BTLS.
All right, if you don't know what the initials stand for, then you're not allowed to read or interpret that.
So you can just move on to starting right here.
Right knee pain, abrasion, left foot.
Judge,
clench.
again, we're gonna object that he's interpreting as PM. He can read it, he can read what is there in front of him.
All right, you're not allowed to interpret any medical information that is on the document. You're not allowed to guess what the initials stand for.
And then just this last line right here.
Left foot plantar abrasion, blood thinners, minor bleeding to lower gums.
And what is the date of service?
10/21/2023.
Okay, thank you. Now you stated that you did not write a report, is that correct?
Correct.
Is that something that's common when multiple officers are responding to a scene?
Yes,
And you did notate the scope of your duties on scene in the key card, is that correct?
yes.
Okay, and so ultimately, you did not, who is the person that took the report writing duties?
Officer Gapin.
Did you have an opportunity to observe any video evidence on that date?
No,
Okay, and why is that?
I did not look at the video because I was not continuing to handle the preliminary investigation.
Okay, when you say you're not continuing to handle, does that mean that you kind of just handed off the investigation to Kyle Gapin?
Yes,
Okay, and so did he consult you in any way about what offense he was writing up or anything like that?
no, I do not recall.
Okay, did you have knowledge of his report and the offense associated with that before today?
No,
Okay, and have you had a chance to review the video evidence associated with the case?
yes,
After reviewing that video evidence, would you have reached the same conclusion as Gapin?
Judge, that calls for a legal conclusion. He didn't write a report.
Well, Judge, I'm
She's
gonna
asking him to rely
I'm
on
gonna add that we
hearsay.
approach for this sidebar.
All right, approach. All right, you may proceed.
Thank you. So I'm just gonna back up a little bit. So it was your testimony that you were the first on scene, is that correct?
yes,
And on scene, you took a statement from Mark Planton, is that correct?
yes,
Okay, and you further took a statement from the defendant Darren Johnson, is that correct?
yes,
And then further, you took a statement from Aaron Rodriguez, is that correct?
yes.
And you were the only officer that spoke to Aaron Rodriguez on that day, isn't that correct?
I don't know.
Okay, and when you spoke with the defendant, did she show you any video evidence?
No,
However, you observed all the parties and took statements from everybody that you deemed relevant to the investigation, correct?
Yes,
And after doing that, Officer Gapin comes in and kind of assists in the or takes over the investigation, is that correct?
yes,
And so he took statements from the defendant Darren Johnson and Mark Clanton. Do you know if he did that?
yes, that's what he would have done, yes.
Okay, and so then he writes a report. Did you write a report charging anyone with an offense?
No,
Okay, and you did not have the opportunity to view video evidence on scene, correct?
no,
But you've since viewed that video evidence, is that correct?
yes,
And after viewing that evidence, would you have written a report against?
Well, just a second, let me hear the question.
After viewing the video evidence, would you change the course of your investigation? Or would you leave it as is? I guess let me rephrase the question. Well, I guess, are you gonna, go ahead.
Well, is that the question?
Well, I was gonna rephrase, but if you want to object to that question, go ahead.
The way it was asked, Judge, was in my objection.
All right,
You want to approach?
all right, the previous objection will be overruled to that question.
Can you approach?
Yes.
Since that day, have you had an opportunity to review Officer Kyle Gapin's report?
I did so today.
Okay, and in your review of the duties that you did on scene, right? So taking witness statements, and then since that day, viewing video evidence, would you have wrote up an offense on either party?
Judge, that's not relevant.
All right, the objection to relevancy will be sustained.
Would you change any of the things that you did on scene that
Again,
day?
Judge, that's not relevant.
All right, that will be sustained.
In totality of everything that you viewed on today, with the things that you did on the offense day and the evidence that you've reviewed since, would the conclusion of the investigation that you conducted on scene have changed?
Judge,
All right, could everybody approach?
Okay, and so on scene, you decided to not write up any offense against anyone, is that correct?
Yes,
Okay, pass the witness.
officer, thank you, Judge. Officer, you were first on scene, but you weren't the primary officer, is that right?
correct.
Okay. What are the duties of a primary officer?
The primary officer is gonna have to write the offense report and make the decision on really who's gonna be the suspect and the victim. After speaking with everybody, taking the statements, figuring out what happened.
And so, for lack of a better term, he's not really the boss out there, but he's the lead officer, is that right?
Yes,
So it's his duty at that point in time to gather all the information that he's aware of in speaking with other officers, is that right?
yes,
Speaking with the witnesses,
yes,
looking at all the evidence they possibly can.
yes,
And then based on all of that, he writes his report, is that right?
yes,
Your job then at that point in time was just to say, I'm here, let me just get a general idea of what is happening.
yes,
And that's what you did.
yes,
And in fact, in watching that video, you didn't even give any kind of first aid at all.
no,
Okay. You just kind of got, this is a general idea what's going on, then all the other officers come in, is that right?
I was handling the investigation and then it was taken over by Officer Gapin at the request of his field training officer.
In fact, because it's taken over, you didn't even write a report.
Yes, that's correct.
So your memory right now is based on just the video you saw
Yes,
of them. I'll pass it to this judge.
And no further questions for this witness, Judge.
All right, is this witness excused?
By the state, yes, Your Honor.
All right, you may step down. Make sure you leave the exhibits with the court reporter. State, call your next witness.
State called Aaron Rodriguez.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so that the members of the jury can hear. If you'll state your name for the record, please.
Aaron Rodriguez.
All right, state, you may proceed.
Aaron, how old are you?
I am 19.
And what city do you currently live in?
San Antonio.
How long have you lived in San Antonio?
My entire life.
And did you attend high school in San Antonio?
Yes, ma'am.
What high school did you attend?
James Madison High School.
Okay. Are you employed currently?
No, ma'am.
Okay. What are your plans for the future?
Recently I'm trying to talk to a recruiter about joining the Texas National Guard.
Okay. Now I want to talk to you about October 21st of 2023. Do you recall that day?
Yes, ma'am.
And where were you on that day?
At my girlfriend's house.
And on what street does your girlfriend live?
Flairwood.
Okay. Does your girlfriend have a next door neighbor?
Yes,
Who are the next door neighbors, if you know?
ma'am. Ina Clayton and was Mark Clayton too.
Okay. When you say was Mark, what do you mean by that?
Before he passed away.
Okay. And so Ina and Mark are the neighbors of your girlfriend's grandma, is that correct?
Yes, ma'am.
Okay. And so you were at the house on that day, is that correct?
Yes, ma'am.
And were you inside or outside?
I was outside.
Okay, what were you doing outside?
I was in the front yard or by the front door on the phone with my grandmother.
Okay. And so if I'm you, right, and I'm at your girlfriend's grandmother's house looking out towards Flairwood Drive, Ina and Mark's house is located where, on the left or the right side?
The right side.
Okay. And so you're standing there, and did you observe anything out of the ordinary on that day?
No, when I went outside, it was pretty normal. I actually witnessed Mark putting his trash cans outside. And, but other than that, no.
Okay. Did you observe anything regarding the trash cans, later on after Mark put them?
Rephrase the question?
Okay, so you observed Mark put his trash cans out, is that correct?
Yes.
Okay, and then what happened regarding the trash cans after that?
Shortly after, a white pickup truck pulled up and, she got out, moved the trash cans to his driveway. And, he asked her to not touch his property, which he then proceeded to move them back to where they were. And, then she got back in her pickup truck after moving them, and I heard the engine rev, then put into gear, and that's when he fell, and I witnessed the truck hit him in the front right part where the headlight is.
Okay. So when you say her got off the truck, who are you referring to? If you don't know her name, that's okay, but do you see the same person in the courtroom today?
Yes, ma'am.
Can you please point to her and identify her by an article of clothing?
She's wearing the gray jacket.
Thank you. And so when you observe the truck, did you get to observe if it like went up on the curb?
Yes, ma'am.
It did?
Yes.
Okay. And after the collision, what happened with Mark?
He was, what I seen, he was thrown to the ground, which concerned me because I thought he actually had gotten run over. So at the time I ran inside and told my my girlfriend's grandmother to call the police and possibly EMS.
Okay. Do you know, did police arrive on scene on that day?
Yes.
And did you talk to any police officers?
Yes, ma'am.
Do you recall how many police officers you spoke with?
Only one.
Okay. And I'm gonna publish state exhibit number 3. And you have a screen up there, but if you need to, you can turn around and look on the big screen. So I'm pausing the state's exhibit. We see an individual in a white shirt and black basketball shorts. Do you know who that person is?
Yes, ma'am.
Okay, and so this home that I'm toggling the mouse over right here, do you know whose home that is?
Yes, ma'am.
Whose home is that?
Ina and Mark Klein.
Okay, and then this home that I'm toggling my mouse over, whose home is that?
That is my girlfriend's house.
Okay, and so you were standing in front of this house when you observed this, is that correct?
Yes, ma'am.
Okay. And on state's exhibit number 3, is that you providing a statement to the officer that spoke with you on that day?
Yes, ma'am.
Okay. Now, I'm going to show you what has been marked as state's exhibit number 5. Do you recognize this? Is this a copy of a video that you've previously reviewed?
Yes.
And does this video fairly and accurately depict the events as you observed them on the offense date?
Yes.
And except to comply with legal rules, has it been altered in any way?
Not that I know of.
At this time, the state offers state's exhibit number 5.
No objection, John.
All right, state's exhibit number 5 is admitted without objection.
A permission to publish, Your Honor.
Granted.
And so on the state's exhibit, these trash cans that you observed, who placed them out there?
Mark.
Okay. And the person that's moving the trash cans on the state's exhibit, is that the same person that you identified in court today?
Yes, ma'am.
And do we see another truck driving on the street
Yes, ma'am.
and another car?
Yes, ma'am.
And after you observed the collision, what did you do?
I proceeded to go inside. Well, first I hung up the phone with my grandmother, explaining what happened. Then I went inside to tell my girlfriend's grandmother to call the police.
Okay, and then after you did that, what did you do?
I went outside to go check on Mark.
And is that you that we see where I'm toggling my mouse?
Yes, ma'am.
We passed the witness, Your Honor.
All right, defense.
Good morning. My name is William Davidson. I'm gonna ask you some questions.
Okay.
Now, you said that you were out there and saw this,
Yes, sir.
and was it your testimony a minute ago that you were on the phone with your grandmother explaining what happened
After the fact, yes, sir.
after the fact? But would you agree with me, there's quite a bit of time that goes by, you're not seeing in the video, you're not seeing running up there to check on him or anything, are you?
No, sir.
Okay. And you're aware that this happened back in 2023 and that Mr. Clanton didn't pass away until late 2025 or early 2025 for some other reason?
Yes, sir.
Okay. And would it surprise you that the officer who was running this investigation said he talked to everybody and that he didn't find any witnesses that were there?
That is not of my knowledge.
Now, would you agree with me that video is coming from a different angle than what you say you saw?
Yes.
And you're aware that it was from our client's front door?
The video footage?
Yes,
Yes, sir.
that's what Your Honor.
No further questions, Judge.
All right, is the witness excused?
Yes, by the state, Your Honor.
All right, you may step down. State, call your next witness.
The state calls Detective D. Smith.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, and make sure you keep your voice up so that members of the jury can hear.
My name's Detective David Smith.
All right, you may proceed.
Detective Smith, how are you currently employed?
The San Antonio Police Department, work our fusion unit.
Okay, how long, are you a certified peace officer?
Yes, ma'am.
How long have you been with the San Antonio Police Department?
28 years.
And your current title and assignment, well, let me back up. What kind of training did you undergo to become a law enforcement officer with SAPD?
I went through our police academy for 7 months and then ongoing training from there.
Okay. Now, what is your current title and assignment with SAPD?
I'm an intelligence detective with our Southwest Texas Fusion Center.
Typically, what does the Fusion Center deal with?
Generally, I do follow-up work for cases. We have a variety of cases. We deal with anything from obstructing highway to weapons cases, unlawful carrying, that kind of thing, all the way to terroristic threats with school threats, things like that.
Okay. So if I'm understanding correctly, if a patrol officer makes the scene and writes a report, it would be forwarded to you for follow-up investigation. Is that correct?
Correct.
Okay. And were you assigned to conduct follow-up investigation on SAPD 2323-6613?
That case number sounds familiar.
Okay. Well, were you assigned for follow-up investigation for the case that we're here for today?
Yes,
Okay, and did you generate a supplemental report associated with that?
I did.
Okay, and would it help refresh your memory if you had a copy of that up there with you?
I've read it recently.
Okay. So I'm gonna show you what has been marked as State's Exhibit number 7 for identification purposes only.
Oh.
Is that a copy of the report that you've written?
Yes,
Okay, and is it a fair and accurate depiction of the report that you generated associated with this call?
yes, it appears so.
Okay, and so can you just let the jury know what the SAPD case number associated with the call is?
SAPD 2323-6613.
Okay, and can you explain to the jury how you ended up with that assigned to that call?
This case was originally written as an obstructing highway passageway, which includes streets, sidewalks, that kind of thing. And it was assigned to me.
Okay. And what did you do once you received the case?
I read the original report. I haven't read the original report recently. But when I read the original report, I made contact with the complainant of that particular case. That complainant indicated to me that she had video of the incident that took place where he was obstructing her passageway or her ability to move on the roadway. So I asked her to send it to me. She was the complainant. She sent me the video. After watching the video, I realized that the elements of the offense for obstructing the passageway weren't there. And I informed her of that. She wanted me to help her because apparently she had some dealings with this.
Hold on.
Okay.
I'm just gonna stop you right there, okay?
Okay.
And so after you observed the video evidence, I'm gonna show you what's been marked or entered into evidence as State's Exhibit number 5. And if you have a screen in front of you, but if you need to turn around, you can do so to view the State's Exhibit.
I can see here.
Is that the video that was provided to you? And the victim at the time, the victim of the obstruction, was that the defendant Darren Johnson?
Yes,
Okay. And so she sent you this video, is that correct?
correct.
And she purported it to be a fair and accurate depiction of what occurred?
Yes.
And after viewing that, what was the result of your follow-up investigation of the case?
My follow-up, I didn't feel that the elements of the offense for obstructing a passageway were present, and the case was unfounded.
Okay, and on State's Exhibit number 5, isn't it true that we observed multiple vehicles traveling along the Flairwood Drive?
Certainly.
And then after you deemed the obstruction charge unfounded, who did you pass the case off to?
It went over to homicide ultimately.
And so at that time, did a different detective take over for follow-up investigation?
Correct.
We pass the witness, Your Honor.
All right, defense.
Detective, my name is Robert Porter. In all fairness, you and I know each other quite
Yes.
some time. Been
A while.
a while. Detective, so you were assisting Dylan Myers?
I'm sorry?
Were you assisting Detective Dylan Myers?
I didn't have much contact with him.
Okay, so your job was then, as a detective, just to see as far as whether this was an obstruction case or not, is that right?
Right.
Okay, whether to charge this gentleman with obstructing or not?
Correct.
You weren't making any recommendations about anything else?
I felt like the elements could be there for another offense. Therefore, I sent it. That's why it was sent over to.
Okay, and we say could, right, without
Correct.
further investigation.
Correct.
So your limited in scope was just to do homework, I guess, for better statement, homework on the original police officer, is that right?
It's follow-up work.
Just follow up.
Correct.
So, and that's all you had to do with this case?
Correct.
Excellent.
No further questions.
All right, is this witness excused?
What, I'm sorry, Judge, can I have one more question?
Yes.
Did you ever go out to the scene?
I did not.
All right, is this any other questions?
No, Judge, excused by the state.
Excused?
Excuse.
All right, thank you. You may step down. Just make sure you leave the exhibit with the court reporter and remove the mic.
Thank you.
State, call your next witness.
The state calls Officer L. Sanchez.
If you'll raise your right hand, do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. Make sure you keep your voice up so that the members of the jury can hear.
Lawrence Sanchez.
All right, state, you may proceed.
Officer Sanchez, how are you currently employed?
I am an officer with the San Antonio Police Department.
How long have you been with the San Antonio Police Department?
I've been with them 5 years now, ma'am.
Are you a certified peace officer?
Yes, ma'am.
And what kind of training did you undergo to be a law enforcement officer with the San Antonio Police Department?
I went through 7 months of training at the San Antonio Police Department Training Academy. Spent 3 months on FTO program and then additional year on probation.
And what is your current title and assignment with the San Antonio Police Department?
Right now, I am assigned to the North Safe Unit, which stands for the San Antonio Fear-Free Environment.
Okay. And what are your duties as an officer with the Safe Unit?
We work as a liaison between the police department and neighborhood communities. We engage with community leaders. We assist with homeless abatements, council complaints, neighbor disturbances, and code violations.
Okay. And were you employed as an officer with the Safe Unit on November 1st, 2023?
Yes.
And were you on duty that day?
Yes, ma'am.
And were you dispatched to Flairwood Drive to conduct follow-up investigation?
Yes, ma'am.
Do you recall the SAPD case number associated with the case that we're here for today?
I do not recall the exact case number, ma'am.
Did you generate a supplemental report at the time?
Yes, ma'am.
Would it help you to refresh your memory if you had a copy of that?
Yes, ma'am.
I'm showing you what's been marked for identification purposes as State's Exhibit number 6. Do you recognize this document?
Yes, ma'am.
And are you the author of that document?
I am.
And is it a fair and accurate depiction of the supplemental report that you generated for
Yes.
this case?
Yes, ma'am.
Okay, you can use it to refresh your memory, just don't read from it, but can you please tell the jury the SAPD case number associated with the case?
Yes, it's going to be SAPD 232-36613.
Okay, and can you explain to the jury how you ended up with the case for follow-up investigation?
Yes, ma'am. So on November 1st of 2023, I was contacted by our fusion unit. Like I said, my job, one of the aspects of my job is dealing with neighbor disturbances. They had this case assigned to them. It was stated, it was told to me that the original case.
Object, Your Honor, it's hearsay.
Sustained.
Okay, so without saying what you're told, just explain to the jury how you ended up with the case. So you, if I'm understanding correctly, you were contacted by Fusion and they were asking you, it didn't fit the crimes that they investigate. Is that fair to say?
That is fair, yes, ma'am.
Okay, and so they felt that the appropriate unit would be the state unit, which is your unit.
Correct, yes, ma'am. They deemed it that I could assist both parties. Essentially, it was a neighbor disturbance. So they sent it to me to see if I can assist both parties further. And that's how it came to my desk.
Okay, and then so once you received the case, what was the next step that you took?
So part of the case, there was email sent to me as well as a video of the incident that was provided by the defendant. I looked over the video, saw the entire video, and after looking at the video, talked to my supervisor and let him know what was going on. And we came up with the plan to just go out and interview the victim to see if there's any other additional elements to the offense that occurred. So that's what I did, is went out there and just took a witness statement.
Okay, and so who are the individuals that you took witness statements from on November 1st of 2023?
It would be Mr. Mark Clanton.
Okay, and when you took the witness statement, did you make any observations regarding Mr. Mark Clanton?
Yes, well, he stated to me that he had bruising on his left arm.
Sustained.
I observed scabs on his right knee and his right foot.
Okay. And then after reviewing the video evidence and taking the witness statements, what did you next do with the case?
I contacted the follow-up unit again, or the detective at Fusion. Contacted him, let him know what was stated to me, let him know what was going on. I contacted my supervisor as well, let him know what was going on. And then we ended up contacting a homicide detective, let him know the entire situation. And after that, it was just deemed that I should write a supplement to the original case that was already reported.
Okay, and the supplemental report was for what offense?
It was going to be for the aggravated assault with deadly weapon.
Okay, and then was the case forwarded to another unit for more follow-up investigation?
Yes, ma'am.
And what unit would that be?
It would be the homicide unit.
Okay, and after it's transferred to the follow-up unit, is that like the end of your duty for the case?
Correct, yes, ma'am.
Okay, we passed the witness.
All right, defense.
I'm William Davidson. I'm gonna ask you a few questions.
Yes, sir.
Were you on the scene that day?
On the initial day of the report on October 21st, sir?
Yes.
No, sir.
And so your report was written later, correct?
Yes, sir.
And as part of your report, you would agree with me, you reviewed Kyle Gapin's report and other information, is that correct?
Yes, sir.
And you just testified that you went out to talk to the victim. The victim in that report was really my client, wasn't it? In the report.
In that report, it was, yes, sir.
It was. But you didn't go out there to talk to that victim, did you?
No, sir.
So you never talked to her, did you?
No, sir.
Okay. And you weren't a witness to any of these events, obviously, because you weren't there, is that correct?
That is correct, sir.
And the original video that you watched, you obtained that from who?
Detective Smith.
That's what it's on.
Okay, just briefly. So you received the evidence in this case from Detective Smith, is that correct?
Yes, ma'am.
Okay, and so what was forwarded to you included the offense report of Officer Kyle Gapin, is that correct?
The case number was forwarded to me as well as the emails that were sent from the defendant.
Okay, and so under the case number with the case management system that SAPD has, you're able to look up the reports and key cards and everything, is that correct?
Yes, ma'am.
Okay, and so in Officer Gapin's original report, the defendant was originally listed as the victim, correct?
That is correct. Yes, ma'am.
And the case ended up with you because Detective Smith spoke with Darren Johnson and deemed that report unfounded, is that correct?
That is correct.
Okay, and so it was forwarded to you at that time for additional investigation concerning Mark Clanton being the victim of an assaultive offense, is that correct?
That is correct.
We passed the witness, Your Honor.
And when did you review the video?
November 1st, sir.
November 1st. Nothing further on.
And any further questions?
No, Judge, excused by state.
Is this witness excused?
Yes, sir.
All right, you may step down if you'll leave your exhibit with the court reporter. All right, ladies and gentlemen, I know I said I would give you a break at 11:30, but I like for both parties to be able to direct and cross the witness if they choose to do so. So it's 11:15, so we're going to take our break now. I'm going to have you all back here at 2:30, and the reason why we're starting at 2:30 is because I have an afternoon docket. It's unrelated to this case. Remember my instructions. You are not allowed to start deliberating with yourself internally. You're not allowed to deliberate with each other. You're not allowed to talk about this case to anyone. You're not allowed to do any investigation. Don't Google names. Don't go to locations that you may have heard about. Make sure your badges are always visibly displayed. And when we start at 2:30, you'll just be waiting for us in the jury room, all right? Everyone, please be seated and state, call your next witness.
The state calls Detective Dylan Myers.
All right, if you can raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record. Make sure you keep your voice up so that members of the jury can hear.
Detective Dylan Myers, SAG homicide unit.
All right, state, you may proceed.
Thank you, Judge. Detective Myers, how are you currently employed?
I'm at the homicide unit where I've been for 3 years.
And what department is that with?
In San Antonio Police Department.
Are you a certified police officer?
I am
How long have you been employed with the San Antonio Police Department?
just over 9 years.
What type of training did you undergo to become a police officer with SAPD?
Went through an 8-month academy where we learned penal code, code of criminal procedure, traffic code, did tactics, how to handle calls, shooting drills, and fitness tests.
Okay. And then after you graduate from the academy, what's the next step in training?
We get put on patrol somewhere in the city. There's 7 service areas now, so one of those service areas usually overnight.
Okay. Prior to being at homicide, did you have any other assignments with SAPD?
When I first promoted, I had 5 years to detective. I was a uniformed evidence detective. So basically CSI, I did that for about a year. And then I went to homicide after that.
Okay, and just so the jury is aware, CSI, does that mean crime scene investigation?
For UEDI, it's uniformed evidence detective investigator. So I would take photos of family violence, for instance, collect evidence. I didn't do all the stuff CSI did. The major crimes were handled by them, but I was there as an in-between basically.
Okay. And you said when you promoted to detective, do you have to take an exam for that, or what is that process?
Yes, there's a civil service examination that you can take at 5 years on as a step C officer, 5 years. And so once you're eligible for that, you test. If you score high enough with seniority and there's vacancies, then you get promoted.
Okay. Now, your current title and assignment is with homicide, is that correct?
Yes,
And how long have you been with homicide?
about to be 3 years.
And what are your duties as a homicide detective?
I investigate 60+ offenses on the aggravated assault side of homicide. Homicide is divided into 2 sides. We call them murders and then the aggravated assault side. Murders deals with the officer involved shootings, in custody deaths, and obviously murders. And then aggravated assaults has a variety of offenses, but aggravated assaults are bread and butter. They're the main thing we deal with.
Okay. Now, were you employed as a police officer on November 2nd of 2023?
I was.
And was that as a detective with the aggravated assault unit of homicide with SAPD?
Yes.
Okay. And were you assigned to do follow-up investigation on a case under SAPD case number 23236613?
Yes.
Do you recall how you ended up with that case?
I was assigned it by my supervisor in the homicide unit.
Okay. Once you received the case, what did you do to further investigate?
Well, first I saw that the offense had originally been written up as impeding roadway. My sergeant spoke to me about it, said that Fusion, which handles that offense, had done their investigation, determined it didn't meet the criteria for them. And so then it was passed over to homicide because he believed it might meet a criteria for an offense for us.
Okay. And so once you received the case, under that case number, were you able to look at all of the evidence that was contained under that case number?
Yes, all the body worn cameras, the in-car video, any video that's uploaded, all gets linked to that case number or that CFS.
Once you received the case, did you review the evidence that was associated with it?
I did.
And did you identify any witnesses that you believe needed to be interviewed?
No, all I had seen from the initial report was the victim and the suspect. So they had already been interviewed by a Fusion detective, but I was going to redo for my investigation, interview them again after I reviewed all the evidence.
Okay, and so did you conduct additional interviews with Mark Clanton and Darren Johnson?
Yes, I did.
All right, and how are these interviews conducted?
For this case, it was by phone.
Okay, and specifically regarding the interview with Darren Johnson, was that phone call recorded?
It was. All of our phone calls we make have to be recorded with witnesses, victims, suspects.
Okay, and did you give her a warning that the statement was voluntary and she could end it at any time?
Yes, something along the lines of you don't have to talk to me if you don't want to.
Detective Myers, I'm showing you what's been marked as State's Exhibit number 8. Do you recognize this disc?
Yes.
And is this a fair and accurate, or what is contained on the disc?
I have a recording of the phone call I had with Darren Johnson.
And is it a fair and accurate depiction of the conversation as it occurred?
It was spliced a little bit in order to get rid of the necessary
Excuse me,
parts.
Your Honor.
Yes.
I would object to him going on any further as to what is on this.
All right, do you have any objection to State's Exhibit number 8?
No.
All right, are you offering State's Exhibit number 8?
Yes.
All right, then State's Exhibit number 8 is admitted without objection. Granted.
I got this case assigned to me regarding you and Mark Clayton. I can decide of what occurred. I was calling to try and get your side. You don't have to. Well, I'll tell you, I'll just have to tell you, if you don't want to, you don't have to tell me. I just got.
I want to like you, I asked you if you're still video,
Yes, so I just did it.
and then did you do it with the phone?
Yes.
think you did something about, you can't touch my trash can or something like that. Maybe that's your opinion. No, I did not. You said something.
You pull up to your residence.
I was looking there. You basically got a grocery. Basically, I just said that I was cashing the clean family. You know, this year we drove, so I was looking at the family with the trash can. So, except for the traffic, I was just looking at the school. And I just really started to be and I stopped immediately.
So I saw all of that. That's from your house, right?
Yes, yes. Yeah.
When you did the video, did you tell me that he jumped in front of the car, right? I mean,
Yeah.
obviously, he's in the same, he's not jumping anywhere, but I jumped when he, like, moved in front of your vehicle. Is that what you're saying?
Like he hit the vehicle with his hand and then fell back on the ground. First. Correct, the only thing I have is the video, yeah, that's true.
As you actually go and drive, you're looking from the rearview mirror on the side, right?
Correct, that's true.
So you're not sure, you can't know where he was in that regard, then if you're looking back, right?
I looked in the video, I'm very much in the head, so crazy,
Okay, yeah, and he had no major, well, do you know how this report was originally written up?
I haven't seen it yet, I talked to David Smith, the company David Smith, and he
Okay, and I'm gonna show you what has been entered into evidence. State exhibit number 5. All right. If you could just explain to the jury what we are seeing on the state's exhibit, and you can use the big screen, if you need.
This was the video provided that was already uploaded in evidence.com of the incident in question.
And so, we see some movement over here in the trees, and then if you can just explain to the jury what you observed.
So it appeared to be Miss Johnson moving the bins over there, and then Mr. Clanton coming out and moving the bins back.
Okay, and then what are we seeing right now?
Mr. Clanton bringing the bin back out to the curb.
Yeah, I'm just gonna go back a little bit. Are we able to see, the defendant driver's side door on this video?
Yes, it's near the top left. You can see it behind the branches.
And is that right here?
Yes.
And are we observing the door shut right here?
Yes, you can see Miss Johnson getting back into the vehicle and the door shutting.
And then who is that we are observing coming into view?
Mr. Clanton.
Okay, and what are we observing occur with the truck?
Is beginning to move again.
And where's Mr. Clanton in the video?
Right on the edge of the curb.
Is there anything significant about the tires on the truck?
So before that, you can only see the bottom of the rim. You can't really see the bottom part of the tire. At this point, you can see the tire, which led me to conclude that the tire had gone up onto the curb at this point. And then at that point, it appeared to have gone back off of the curb because you can no longer see the bottom portion of the tire. You can only see the bottom of the rim.
And so as part of your investigation, after you took statements from Darren Johnson and Mark Clanton, I guess I want to talk to you a little bit about her statement. And so in the statement, did she tell you that she had heard Mr. Clanton come outside?
Yes,
Okay, and that he was actually speaking to her at some point, is that correct?
she said he was yelling something about the cans.
And at this point, when you spoke to her, the offense date is October 21st, 2023, is that correct?
Yes,
But you speak to her days later on November 2nd of 2023, is that correct?
that was around the time I got it. Yes.
And just regarding the statement that she made to you, at this time, she states that she wasn't actually looking forward when she put the car in, or the motor vehicle in drive, she was looking backwards, is that correct?
Yeah, she said she was looking at either the rearview mirror or the side mirror. And at one point, she says the rearview mirror, looking at the cans that were now behind her.
Now, regarding where the trash cans were depicted on the state's exhibit, are you able to observe this cinder block line right here?
Yes,
Okay, and do you know what that is?
the dividing line of their properties.
Okay, and so the trash bins were on the left side of the dividing line in front of the Clanton's residence, is that correct?
They appear to be from the angle of the video.
And so in your training and experience, I mean, is a person able to use force against somebody to move trash bins?
No,
And in your training and experience, I guess you said you worked homicide and aggravated assault cases, is that correct?
yes,
And in your training and experience, is it possible for a motor vehicle to be used as a deadly weapon?
yes.
Now, after you conducted your investigation, what was the result of your investigation?
I changed the offense to aggravated assault deadly weapon, and I switched victim and suspect, because originally Mark Clanton was written up as a suspect of impeding roadway, obstructing passageway. And I switched it for Darren Johnson to be the suspect in aggravated assault deadly weapon, and Mark Clanton to be the victim.
Okay, and why did you do that?
Because just from watching the video and from her statement, from looking in the rearview mirror, even though I can, from the video, you can see her re-entering her truck. When you re-enter the truck, you face the truck. She had to have seen Mark Clanton walking by with the trash can at that point, and then popping up onto the curb while he's bringing the trash can back out. I believed it to be causing bodily injury recklessly. with a deadly weapon.
Yeah, just making assumptions here and speculations.
Sustained. Ladies and gentlemen, you disregard the last answers.
We passed the witness hearing.
Detective Myers, you got this case about 11 days after the incident, is that correct?
Yes, sir.
And so you weren't there when this happened, correct?
No, sir.
And when you watched this video, did you notice this whole thing that we just talked about over a period of several minutes happened in less than a second? Did you notice that?
It went really quickly. I had to slow
Went
it down.
quickly, didn't it? Yeah.
Yes, sir.
And are you able to see more slowing it down, or do you see it all at the normal pace?
You can see more slowing it down.
I understand. What is this?
A water bottle.
You see any water in it?
Yes, sir.
Okay. Now, when I cover up this water, you see water in it now.
No.
If I raise this, do you see water?
Yes.
Why do you see water now and not then?
It's my perception of where the bottle is in comparison to the folder you're covering.
Okay, so this is covering the water, correct?
Yes, sir.
And if I pull this down, you see the water, correct?
Yes, sir.
And the same event happens if I pull this up, correct?
Yes, sir.
But they're two different actions, correct?
Sure.
And did you go out to the scene?
No, sir.
And you're detective, you don't think it's important to go out to the scene?
We don't go out to every scene, sir.
You go out to some scenes?
We do go out to some scenes, yes.
So for a second-degree felony, it's not important to go out there and check it out?
I had the evidence that I required.
Oh,
for this
really,
case.
really? Then you can tell me about the curb. Tell me about that curb.
For the curve of the curb,
Yeah,
I couldn't tell you the exact grade of the curve or what degree it is. I
And that
don't bring a
doesn't matter.
protractor out.
I'm sorry. Go ahead.
I don't bring a protractor out to scenes. That would be a TIE thing.
Did you talk to TIE?
Yes, they're actually in the same office.
Okay, and what did they tell you?
That this does not meet an accident, that it meets an aggravated assault.
I'm not asking you about that. I'm asking you about the curb that you say you know about because you're an investigator.
I said that I don't measure with a protractor, a slight curve in the street.
Okay, so you say you saw the water, then you didn't see the water. I'm going to show you State's Exhibit 1, which has been entered into evidence, and ask you if you recognize this. Defense, I'm sorry. You recognize that?
That's the area where it happened.
Okay. Anything different about that curb?
The curve goes down a little bit.
It does. And if it goes down, that allows you to see the tire, correct?
That would be one way, yes, sir.
Okay. Now, you called Mark Clanton first and then my client, correct?
Yes, sir.
Did you warn Mark Clanton like you did my client?
No, sir.
Why not?
At that point, he already wasn't a suspect of the obstructing roadway.
So you already made your determination before you made these phone calls.
I didn't make that determination. The fusion detective made that determination when he said he wasn't a suspect of an obstructing roadway.
Now, the state asked you about, or you mentioned she kept telling you she was looking in the mirrors and stuff like that.
Yes, sir.
Isn't it true that you were more or less saying, weren't you looking in the mirrors and you were leading her to say what she said?
No, sir. That was the first thing she said.
Okay.
I asked where she was looking and she said in the rearview mirror.
Yeah, the jury can hear that for themselves and determine that.
Okay.
And these are the only two witnesses you interviewed.
Yes, sir.
Now, based on the time that you looked at the video the first time and now, you don't notice any tampering, is that correct?
With the video,
Yes.
no, this is the same that I viewed.
Okay, thank you. Now, you stated earlier you didn't go out to the scene, correct?
Yes, sir.
And so you don't know the distance between the houses or the driveways, is that correct?
I couldn't tell you the measurements, no, sir.
Yes, Liz.
No further questions.
All right, is this witness excused?
Yes, Judge.
Great, you may step down. Please leave the exhibits behind. State, call your next witness. Yes.
And I guess this is kind of two parts since we're just gonna go over her testimony. I did have something that I wanted to ask her about, and then I would make argument to the court about.
All right, so this is the way I'll handle this hearing. I'll hear what the questions are. Let me hear what everything is, and then at the end, I'll allow everyone to make their objections. Because the only way for the court to determine if testimony should be given to the jury is if I hear everything. All right, Miss, if you'll come up here, please. All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Just make sure you keep your voice up so that everyone can hear, all right? All right, if you'll state your name for the record.
My name is Ina L. Clanton. Z-I-M-A.
All right, state you may proceed.
Ms. Clanton, how old are you currently?
76.
And what county do you currently live in?
I live in Bexar County.
And how long have you lived in Bexar County?
31 years.
And do you know Mark Clanton?
Yes, he was my husband.
And how long were you all married?
56 years.
Do you know why Mark isn't here today?
I'm sorry.
Why is Mark unable to be present in this trial?
He passed away on March the 7th.
And what is that, 2025?
This year, yes.
Now I want to talk to you about the date of October 21st, 2023. Do you recall that date?
Yes, I do.
Okay. And there was an incident that occurred involving the defendant in this case and your husband, is that correct?
Yes.
Okay. And you were not outside to observe the collision of the defendant's motor vehicle into your husband, is that correct?
I was not. He hollered at me and said, she's moving her cans.
Okay. But after the fact, you were able to walk outside and observe your husband, is that correct?
Yes.
Okay, and I'm gonna show you what has been entered into evidence as State's Exhibit number 3, I believe. And so, are you able to see it on the little screen? If you're not, you can turn around and look on the big screen.
I can see it on this screen.
Okay. And so You recognize that person depicted on the screen?
Yes,
Who is that?
it's my husband, Mark Clinton,
And do you know how old he was on that date?
78. He had just gotten out of the hospital.
And do you recognize this person in the white shirt right there?
Yes, that's myself.
Okay. Now after the police left the location, were you able to observe Mark and see if he had any injuries?
Yes,
And did you take photos of those injuries?
yes, I did, on different days.
Okay. I'm gonna show you what's been marked as State's Exhibits 9 through 17. If you can take a look at these photos and tell me if you recognize what's in them.
Yes, that one's my house.
State's Exhibit number 10.
Is Darren Johnson's house and her truck.
State's Exhibit number 11.
This is Darren's house plus is where I had put the cinder blocks to differentiate where the boundary line was in the on the property, because Darren had removed the sticks that the survey team had placed.
Okay. And then what is this?
That's my mailbox,
Okay, and just for the record, what is your address?
13907. Where we
Further back, is that correct?
yes,
Now, State's Exhibit number 13, can you tell me what that is?
that's knee. Knee or elbow.
Okay.
It's his knee because his pants are.
Okay, and what is this right here?
It's a scratch and a scrape from Darren hitting him with the truck.
And State's Exhibit number 14.
That's the bottom of his foot where his shoe had rubbed when he hit the grass.
And then State's Exhibit number 15, is that a healing wound?
Yes, it's a knee.
And State's Exhibit number 16.
And that's his arm that had been bruised.
And then State's Exhibit number 17.
That's his left foot where there are abrasions and redness.
Now I'm going to show you what has been entered into evidence as Defense Exhibit number 1.
Mhm.
All right, just one moment off the record. All right, you may continue.
Okay. So regarding Defense Exhibit number 1, do you know what that is?
Yes, this is about 4 or 5 feet from my mailbox. It's an area where the water repair truck had come in several years earlier, maybe 12 or 15 years. And they had pressure, I don't know what they're called, pressure stabilizers that kept the truck in one place. One is over here to the right, another over here to the left. And as they did their work, they call this the side, this curb itself went down, and the city had never repaired it.
Okay. And how long have you lived at your home on Clearwood Drive?
since 1991.
Okay, and you and Mark both lived there?
Yes.
And then just regarding an incident that occurred back in 2021, do you recall an incident that occurred back in 2021 involving Mark and the tree and the defendant?
Darren Johnson had a habit of cutting our trees, our crepe myrtles in the backyard. She claimed that the petals were going into her pool, and it was too much of a hassle for her to have to take them out of the pool. So she virtually massacred our trees. We were out of town over July 4th weekend, and she had cut the trees. She had a saw. When we did notice that she was cutting the trees, we approached her and asked her to stop. She would not stop. She told me she was a lawyer, and that I needed to call my lawyer. And she continued to move her ladder down the side of the fence, cutting a foot to 2 feet past the fence line.
Sorry.
And then she was cutting, and then she cut my husband with a saw. And she was arrested for criminal misdemeanor.
A misdemeanor offense. Okay. And just regarding that incident with her cutting Mark, did you observe any injuries on him on that day?
Yes, she had cut the back of his hand.
Okay. We passed the witness room.
All right, so if you could step down, please. All right, thank you. And so that both parties are aware, I'm just going to swear her in again.
Judge, and she's been admonished, but I don't know if the court would like to admonish her of the ruling or.
All right, so here are my rulings, just so you'll be aware of them, all right? So you are not allowed to testify that your husband had just been released from the hospital, so don't testify about that, okay? And you're not allowed to talk about the reason why he was moving the trash cans, okay? So to be on the safe side, anything that he told you, if that's where you're getting your knowledge from, you're not allowed to testify to, okay? With regards to the injuries that you say that he had, you're not allowed to say that those were injuries from getting hit by a truck, but you are allowed to testify and say, you know, if there was an injury to his knee or an injury where else, you are allowed to say that there was an injury here or there, just with the photographs that you took, okay? But you're not allowed to say that the defendant caused those injuries or that a truck caused those injuries. And the reason for that is it has to be something that you've personally seen, all right? That's why it's being done. So there are rules in criminal cases, all right? And let me see if there's anything else. All right, with regards to the survey, you know, you mentioned that there were survey sticks. You are allowed to say, you know, if you saw the survey sticks being placed by the people who are in charge of surveying the land to give the boundaries, you're allowed to testify to where those stakes were. You're not allowed to testify if you're saying the defendant removed those stakes or pulled those up, you're not allowed to testify to that, okay? Is there anything else that I missed from either side?
No, Judge.
No, you don't.
All right, so the other thing is when you're testifying, if either of the parties stand up, that means that they're about to object to something. So just stop talking and I'll make a ruling. And if you don't know whether or not you can answer it, just ask me, okay? All right, let's bring them in.
All right, for the jury.
Everyone please be seated. I'm going to swear you in again. So if you can raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you speak up so that the members of the jury can hear. If you'll state your name for the record, please.
My name is Ina L. Planting,
All right, state you may proceed.
Ms. Clanton, how old are you currently?
76,
And what city do you currently live in?
San Antonio,
And how long have you lived in San Antonio, Texas?
since 1991, so that's 34 years.
And what is your current address?
13907 Flairwood Street,
How long have you lived at that address?
since 91, 34 years.
Okay. Do you know Mark Clanton?
Yes, I do.
How do you know him?
He was my husband.
And when you say was, what do you mean by that?
He passed away on March the 7th this year.
I'm very sorry for your loss. Now, what was Mark's date of birth?
December 20, 1944.
And are you currently employed?
Me, no.
Okay. What did you used to do for work?
Well, I've done various things because my husband was in the Air Force. I've worked for an attorney. I worked in a art gallery.
At some point, were you a teacher?
I taught jazzercise.
Oh, okay.
My husband was a teacher.
Okay.
And in that 1991, when we returned, I worked with a company called Independent Horizons, and they housed disabled adults, and I was responsible for 60 adults in their medical care.
Okay. Thank you for that. Now I want to talk to you about October 21st of 2023. Were you living at your residence on Flairwood Drive on that day?
Was
And who was living with you at the home on that day?
my husband, Mark.
Okay. And was there an incident involving Mark where you had to go outside?
Yes.
Okay. And once you were outside, what did you observe outside?
I observed my husband flying through the air and landing on the ground, in the grass.
Object, Your Honor.
Well, I'm gonna ask if we could approach.
But you-
Approach.
All right, you may proceed.
Thank you, Judge. And so I'm gonna show you what's been entered into evidence as State's Exhibit number 3. Do you recognize that individual?
Yes, my
And-
husband, Mark.
Okay, and do you know how old he was on October 21st of 2023?
Was 78.
And so I paused this exhibit at the 3-minute and 4-second mark. Who is this individual in the white shirt?
Myself.
Okay. Now, after police arrived, responded to the scene and left, did you have the opportunity to observe Mark's person?
After the police left.
Yes. And did you observe anything on his body that was not there before you observed him laying on the ground?
He has scrapes on his knees, on his knee, sorry. The bottom of his foot, the side of his foot. He had bruising on his arm. And later he complained of having some pulled muscles in his back.
Okay. So I'm gonna show you what's been marked as State's Exhibits 9 through 17. Can you please take a look at these and just tell me if you recognize them?
This one is my driveway, my house.
Okay, so we're gonna look at them all together and then I'll ask you. Okay. Do you recognize all the objects that are contained in State's Exhibits 9 through 17?
I do.
Okay, and are they a fair and accurate depiction of what's depicted in the photos?
Yes.
At this time, I'm tendering to defense for inspection. Judge, at this time, the state offers States 9 through 17, understanding the court's previous ruling regarding permission to publish, Your Honor.
Granted.
Okay, Ms. Clanton, can you see State Exhibit number 9?
Yes.
And what is depicted in State's Exhibit number 9?
Our two cars in the driveway. That's me standing in the doorway.
And is that your home?
That's my home.
Okay, and that's 13907 Flairwood Drive, correct?
Yes.
All right, regarding State's Exhibit number 10, what is depicted in State's Exhibit number 10?
This is Gary Johnson's home, 13903. With two pickup trucks. One on the street and one in the driveway.
And what is this item that I'm pointing at?
It's my mailbox.
Okay, and what is this right here?
It's a curb of the street.
Okay, is there anything significant about the curb right there?
I don't remember how long ago, but my previous neighbors had a water leak over by their mailbox, which is on the other side of the truck. They had brought in a very large truck to help repair. And they had these stabilizers that kept the truck in place while they were digging a hole, I believe. And at the same time, the side by the street was pushed down and was never repaired.
Okay, thank you. Regarding State's Exhibit number 11, is that your mailbox depicted right there?
Yes.
And is these cinder blocks that we see, is that a property line divider?
Yes.
Okay. I'm showing State's Exhibit number 13. Do you know what that is?
It's my husband's knee.
And is that a photo that you took after you observed him laying on the ground on October 21st of 2023?
Yes.
And State's Exhibit number 14, is that the injury that you described observing on his foot?
Yes.
State's Exhibit number 15, is that another photo of a healing wound contained on the knee?
Yes.
And State's Exhibit number 16, is that the bruising that you were talking about earlier?
Yes.
And then State's Exhibit number 17, is that the injury that you were speaking of on Mr. Clanton's foot?
Yes, on the side.
We passed the witness.
Defense?
Hello, Ms. Clanton. My name is William Davidson. I represent Ms. Johnson. Just have a few questions for you. When this incident happened, were you inside your house?
I was inside. I heard Mark yelling at Darren, asking her why she was moving
Non-responsive, Your
our
Honor.
trash
I'm
cans.
sorry. That objection will be sustained. Ladies and gentlemen, you disregard the last answer.
I'm asking you a specific
I
question.
was in the house and I was out of the house.
I'm asking you, when the incident happened, were you inside or outside? At that moment?
At that moment, I was inside, on my way outside.
And you don't need to shake your head at me. Now, Let me ask you this. Would it surprise you that none of the officers on the scene listed you as a witness in the case?
No, I'm not surprised at all. There were 6 officers that were there. They were all running around. They didn't know what was happening. And as you know, your client is a very.
Hold on, Your Honor, I don't need to hear do anything but answer the question.
All right. So the way everything works is they'll ask you a question, just answer their question if you can. And then the state, if they have more questions for you, they'll have a chance to answer you more questions, okay? All right, you may proceed.
Yes, witness, Your Honor.
No further questions.
All right, is this witness excused?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. If you'll leave the little microphone behind. All right, state, you may call your next witness.
The state rest.
All right, defense, if you approach and state if you approach, please. All right, state you rest, is that correct?
That's correct.
Defense, you may call your first witness.
Your Honor, the defense rests.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes, Your Honor.
All right, ladies and gentlemen, what's going to end up happening is I'm going to have you all tomorrow here at 9 a.m. At 9 a.m., what will end up happening is both sides will be able to present to you their closing arguments in this case. Remember my previous instructions. Do not think about this case outside this courtroom. Do not start deliberating internally with yourselves or with each other. Do not do any investigation. Do not Google anything. Do not look at anything. So the plan is for tomorrow. I will read to you what is called the jury charge, and then both sides will have a chance if they choose to give their closing arguments to you. All right, any questions before I release you? All right, same things apply. It's going to be Thursday tomorrow, so the same number of jurors will be here at this time. All right, everyone please rise for the jurors. Court is calling 2024 CR 2675 State versus Darren Johnson. Can I have parties announced?
Megan Galloway and Andrew Edelman for the state of Texas.
William Davidson and Robert Porter for Ms. Johnson.
And are you Ms. Johnson? All right. And have both parties had an opportunity to review the proposed charge of the court, state?
Yes, Your Honor, and we have no objections.
Yes, Your Honor, no objection.
All right. Does anyone want a time announcement?
5 minutes, please.
2 minutes.
All right. And are you all splitting your time in any way?
Yes, Judge. I don't think Mr. Edelman needs a time announcement.
All right. So I'll just give 5 minutes and 2 minutes for you all.
Yes.
All right. We're ready.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, the persons that you see in the courtroom are unrelated to this case. That's part of my morning docket. So I'm going to read to you what's called the charge of the court. It's the jury charge. You do not have to memorize it because you will be given the original when you begin your deliberations. Members of the jury, the defendant Darren Johnson is charged in count 1 of the indictment with the offense of aggravated assault with a deadly weapon alleged to have been committed on or about the 21st day of October 2023 in Bexar County, Texas. The defendant, Darren Johnson, is charged in count 2 of the indictment with the offense of injury to an elderly individual alleged to have been committed on or about the 21st day of October 2023 in Bexar County, Texas. To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2, our law provides that a person commits the offense of injury to an elderly individual if she intentionally or knowingly causes bodily injury to an elderly individual. 3, deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Elderly individual means a person 65 years of age or older. 4, a person acts intentionally or with intent with respect to a result of her conduct when it is her conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding her conduct or the result of her conduct when she is aware of but consciously disregards the substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, count 1, aggravated assault with a deadly weapon. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2023 in Bexar County, Texas, the defendant, Darren Johnson, did use or exhibit a deadly weapon, namely a motor vehicle, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Darren Johnson did intentionally, knowingly, or recklessly cause bodily injury to Mark Wayne Clanton by driving said deadly weapon at or in the direction of Mark Wayne Clanton, then you will find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and do not consider the lesser included offense as instructed in paragraph 5, and do not fill out the verdict form for the lesser included offense under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Darren Johnson, not guilty of the charged offense of aggravated assault with a deadly weapon, and next proceed to paragraph 5 to consider whether the defendant is not guilty or guilty of the lesser included offense of misdemeanor deadly conduct under count 1. 5, lesser included offense of misdemeanor deadly conduct. Our law provides that a person commits the offense of misdemeanor deadly conduct if she recklessly engages in conduct that places another in imminent danger of serious bodily injury. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2023 in Bexar County, Texas, the defendant, Darren Johnson, did recklessly engage in conduct that placed another, namely Mark Wayne Clanton, in imminent danger of serious bodily injury by driving a motor vehicle at or in the direction of Mark Wayne Clanton, then you will find the defendant guilty of the lesser included offense of misdemeanor deadly conduct under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Darren Johnson, not guilty of the lesser included offense of misdemeanor deadly conduct under count 1. 6, count 2, injury to an elderly individual. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2023 in Bexar County, Texas, the defendant, Darren Johnson, did intentionally or knowingly cause bodily injury to Mark Wayne Clanton, an individual who was 65 years of age or older, by hitting Mark Wayne Clanton with a motor vehicle, then you will find the defendant guilty of the offense of injury to an elderly individual as charged in count 2 of the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of injury to an elderly individual as charged in count 2 of the indictment. Our law provides a defendant may testify in her own behalf if she elects to do so. This, however, is a right accorded a defendant, and in the event she elects not to testify, that fact cannot be taken as a circumstance against her. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against her. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. You all need to turn your cell phones off. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine their own views and change their opinion if convinced it is erroneous. However, no juror should surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit her and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is not guilty or guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed closing?
Yes, Judge.
All right, you may proceed.
It please the court. Defense, ladies and gentlemen of the jury. Apology. Most of the issues in this case are relatively uncontested. The date, the location in Bexar County, the identity of the actor, the identity of the complainant, the age of the complainant, most of these are not strongly contested. What I suspect will be strongly contested, and what you'll need to discuss when you deliberate, are the mental state of the actor and whether her vehicle qualified as a deadly weapon. Now, ADA Galloway is going to discuss those issues with you later, but right now, what I want to focus on is one particular issue that I noticed during these proceedings, which is this question. Did a 78-year-old man throw himself in front of a Ford F-350? When you examine the evidence, when you examine the statements that the actor made to multiple officers and detectives, the statements of the witnesses, when you have examined all of these, I think that you will conclude that no, he did not. That he stood exactly where he had a right to be. He did not put himself in a position to be struck. He was struck. And when you make that conclusion, then you will need to decide what was the actor's mental state and what was the status of the vehicle that she used. Did it come to the level of a deadly weapon? When you have deliberated on all of these issues, I believe that you will render a verdict of guilty, both on aggravated assault of a deadly weapon and injury to an elderly individual. Thank you.
All right, defense.
So this case began with a 911 call that my client made after an incident. That incident was that she tried to park in front of her house. As you saw in the video, there was traffic coming by. That traffic is coming by because the corner that she's on is a very busy road. It isn't possible for her to back into that spot. She went to park. He had put his trash cans out, or bins, or mulch bins, whatever you want to call them, on a Saturday. Not only when it doesn't get picked up, but when you're not supposed to do it according to city ordinance. So he put him out there to block her from parking in her own spot, even though it's in front of his house. He knew that she used that to park. Now, when she drove up, she stopped, she moved the cans behind her. She got back in and started forward. You don't see some big puff of smoke coming out. You don't, screeching and all that. None of that's available. She started to go forward. As she went forward, he comes running out of the house, grabs a trash can, and goes to the front of the vehicle, a moving vehicle that he knows is moving. Now, whether the vehicle hits him, the trash can hits him, it's impossible to say from the video. Impossible. But what I do know is that the police officers that showed up on the scene, they got it at least half right. They said, well, he was obstructing the passageway, and that's the way they wrote it up. They talked to all the witnesses on the scene. They looked at videos. They made their determination. And remember, they were on the scene. These detectives that came in later didn't think it was important to go to the scene of the crime. Even though they're higher paid, they're higher level, not important to go to the scene of the crime. Why do that? I can read these reports in my own air-conditioned office. Why should I go out there? So they didn't go out there. But what they did do was they saw a video that was blown up bigger than it is on a small cell phone. Now, sometimes that's an advantage. In certain cases where there's robberies or we're trying to see somebody climbing in a window, that's an advantage. In this case, it led to what I call apparent error, because the officers who saw that video didn't say anything about her turning her wheels onto the curb because they didn't see that. But what the detective saw, what Detective Myers told you from this witness stand, was I assume that she drove up onto the curb because I was looking over there and I saw her rim, then I saw the tire, then I saw the rim. So it appeared to me as if she drove up and then went back off. Now, had he gone to the scene, and you have evidence that shows this picture, he would have seen that what happened was not her going up on the curb, but the curb dipping down. And so he changed the write-up 11 days later. And he sent it to the state as an aggravated assault with a deadly weapon. He probably did it in good faith. I'm not saying he was trying to hurt anybody. He probably said, well, this vehicle's moving, the tires are turning, and then they're turning back. She's probably trying to hit this guy. But he didn't go out to the scene, so he doesn't know that. And so the big video showed the tire and the rim, but it didn't show that. And you don't see that unless you go out to the scene of the crime, period. So had he gone to the scene of the crime, we wouldn't be here today because they wouldn't have forwarded this case to the state, period. Now, once the state got it, they began developing more and more information, which is what they do. And they added in the injury to elderly. And then yesterday,
Judge, I'm gonna object to this line of argument. It's improper.
Sustained.
Okay, so we have, at this point, we have an aggravated assault with a deadly weapon. We have an injury to elderly, both are felonies. Now we also have a misdemeanor deadly conduct. In all these cases, there's some mental culpability required. And just like I talked to you in voir dire about a pen, it can be a deadly weapon. It's not automatically a deadly weapon. It depends on how it's used and the intent of the person. Right now, I'm not using it as a deadly weapon. I'm using it as an example. In a similar way, when she pulled up carefully, moved trash cans, got back in her car, started moving forward slowly, he comes running out and apparently pushes this bin in front of the moving car. And again, it's hard to see from that angle. From that angle, it's very hard to see exactly what happened. When he does that, she stops and she calls the police, which is exactly what she should have done. Now, you probably detected animosity between the two parties. And that's true. And some neighbors, for whatever reason, they just don't like each other. But she's not here to be found guilty because she doesn't like her neighbor, but because the neighbor doesn't like her. And it was obvious yesterday when I tried to question Miss Clinton, she wasn't answering my questions. She wanted to talk about allegedly seeing her husband flying through the air. The reason I objected is because she wasn't a witness to that. She wasn't listed as a witness to that. She never said she saw that until right then. And then when I asked her if she was in the house, well, I was in and partly out, partly in and partly out. Okay. I stopped questioning her because she wasn't answering any questions and she was shaking her head at me and getting angry. So I just let it go. Now, all of the police officers that had some part in this that were important to the state testified. The first officer said that there was an Andrew on the scene who you later saw come in here and say what he says he believed. But understand this, Andrew was never questioned by the other officers. And for whatever reason, that first officer on the scene who handed it over to Gapin, Officer Gapin, apparently didn't tell Gapin that. Because Gapin got up here and said there was no other witnesses. Nobody, just the people involved. That's what he said. So Andrew says he saw something. He's 2 houses down. Look at the angle that he's looking at. If you look at the picture of the Clanton's house, on the left is my client's house. On the right, apparently, is where Andrew was at the ground level. He's at a terrible angle to see what happened. He may have seen Mr. Clanton falling back at best, but he wasn't at an angle to see exactly what happened and when. And there's something else. For those of you who watch football, you can watch a game and they have slow motion forward, slow motion backwards, all kinds of trajectories of the football. I was watching one game and they even determined how much force it would take for the quarterback to throw the ball to get to this certain point when a receiver got there. And they detected that he threw the ball 2 pounds too light. 2 pounds too light. Now, as an observer, you can see all that on the computer, but the players that are in that scene, it's microseconds. They don't know exactly how much force. They don't know that. This video that we watched for 15 minutes is 1 second where this happens. It's 1 second where she has to make a decision and where he has to make a decision. He knows the car is already moving, but he thinks it's important to put his hand out in front of it anyway. Now, that's the case. The standard is beyond a reasonable doubt. That means that you've looked at all the evidence and that at the highest charge, beyond a reasonable doubt, she intended to crash this car into the man and use it as a deadly weapon. Then secondly, injury to elderly. It's not just is he injured, but did she intentionally or knowingly do it? It's another high standard. Then now we have in the misdemeanor, deadly conduct. Did she recklessly do it? There's a definition for reckless in here, which is very hard to understand, but part of it talks about gross deviation from normal conduct. Gross deviation, gross being large. So did she, when she was parking, was she completely reckless and exhibiting deadly conduct is what they're asking you to find her guilty of. I'm asking you to find her not guilty in all this because it was an accident. It wasn't a criminal event. The prosecutor started off by giving you an example of a road of 2 lanes that merge into one. And where a person is driving on one lane and they either yield or don't yield to the other car. Now, if you do yield, there can be a problem. I know that because when I was coming home from jury selection on Tuesday, on 151, as you get back towards Alamo Ranch, there's a bridge, goes into one lane. I see a truck coming up on me really fast. I know that we're going to one lane, so I slow down to yield. The problem was he slowed down at the same rate. So we're both yielding. So now I decide, okay, maybe I should just stop the car. So I hit the brake, stopped the car, and he came forward a little bit. But then, I thought it was over. Because he passed me, I thought it was over. 5 miles later, I found out it wasn't over. Why? Because he attributed, based on my actions, criminal intent. He thought that I was trying to do something to him. Because when I came around the HEB, he was stopped with his blinkers on, which I didn't think anything at first, until I passed him. He turned his blinkers off and he gets right behind me. Really fast. And he's right up on me. And I slow down, I pull over to the right, he pulls over to the right, he finally passes me, gives me the bird, blows the horn, and goes off, and I turn one way, he turns another. All because I yielded. So whether you yield or you both come forward, if you're doing the same thing at the same time, an accident. It just happened. But does that mean there's criminal culpability? Does that mean there's recklessness? Does it mean any of that? No. It just happened. It's an accident. It's unfortunate, but it happened. Now, this jury charge is really the law. I don't really like the word charge because it's kind of confusing, I think. I don't know why they ever came up with that. I would just call it the law. But it all requires some element, not just something that happened. So we now have this lesser included offense and misdemeanor deadly conduct. And that has to do with reckless, and again, that's gross deviation from the norm. And you can go through this, and I invite you to read it because it's the law, it's important. Now, the judge told you you can't ask questions. What she meant was that during the trial, you can't question the attorneys.
2 minutes.
But you can question the judge when you're back there. And in fact, if you have a dispute over a certain piece of testimony, and you have to say there's a dispute, you can get the court reporter's record on that testimony, but you have to say that. With an action as normal of Mr. Clanton, I don't know anybody would went out there. I mean, he could have put the cans back after she parked, but that's not what happened. In any case, the standard is beyond all reasonable doubt, which is in there. I don't believe the state has met that. There's reasonable doubt all over this case. The officers who were actually there didn't believe that she did anything wrong. And that's exactly what we said. I ask you to deliberate. All of you have to agree on either guilty or not guilty. If there's a permanent disagreement, that's called a mistrial. Thank you.
If I could just ask.
Yes.
Respect your elders. Ladies and gentlemen, that is something that we all learned as children. And it's a notion that the defendant in this case, Darren Johnson, does not know or appreciate or follow. And we know that because Mark Clanton was a victim of aggravated assault with a deadly weapon and injury to an elderly at the hands of that defendant sitting right over there. And we're going to talk about the law that supports that. Ladies and gentlemen, Mr. Edelman talked to you a little bit about the elements in this case and the evidence that you heard and saw about. Aggravated assault with a deadly weapon. Now, as Mr. Edelman told you, most of these elements are conceded to. You've heard testimony from multiple witnesses about the date of the offense, October 21st of 2023. That's the date that officers went out there, that EMS was dispatched to Flairwood Drive, and Mr. Mark Clanton received EMS treatment for his injuries. In Bexar County, Texas, you heard multiple witnesses testify that Flairwood Drive is located here in North Bexar County, Texas. The defendant, you've seen her on the video, and we'll talk about the mental state The bodily injury, you all saw the EMS records in State's Exhibit number 4 and the photo of Mark's knee that had an abrasion on it. The deadly weapon we'll talk about in a little bit. And then count 2. Same elements, just the only difference is the deadly weapon is missing here and the 65 years of age or older. You heard Ina Clanton testify that Mark was older than that age. Now let's talk about the mental state. We talked about in jury selection that the law does not require you to be a mind reader, right? You are allowed to look at the circumstances and the facts that surround and determine the mental state. So in the jury charge, which is the law that governs you, intentionally is defined as a conscious objective and desire on the date of the offense. So let's look at that. It was the defendant's intention to move the trash bins, and she moved them from the side of the Clantons' property line into the Clantons' driveway. Now let's think about that. When you look at State's Exhibit number 5, which is the video of the offense, those trash bins did not need to be moved or touched by the defendant at all. That was a big street, and there were multiple ways that she could have gained access to that parking space if that was truly her intent. What her intent was on that day was to provoke Mark Clanton and get him outside of his home to engage in an argument with him. We can tell this by her demeanor on State's Exhibit number 5, which is the video of the offense. When you look at her, she gets off of her motor vehicle, she's swinging her arms, she's clearly angry and in a bad mood. And then once the offense occurs, once her motor vehicle collides with Mark, she gets off of her motor vehicle and starts shaking her finger at him. She's not concerned about whether he's hurt or not, and she shows no remorse whatsoever. She stands on top of him looking at him and then goes back to her home to wait on the police. And if you look at, this is on the State's Exhibit number 5, but you can clearly see those cinder blocks, which is the property line, and that the trash bins are on the left side, which is the Clantons' property. Now let's look at knowingly. That means the defendant is aware of the nature of her conduct or the circumstances that exist. I submit to you that she did, because in the statement that she provided to Detective Myers, she stated she knew that Mark was outside, she knew that Mark was concerned about the trash bins, and that they engaged in a conversation with each other. So she knew that he was out there and she saw him moving. But by the defendant's own statement, her actions are reckless. Reckless is defined as consciously disregarding a substantial and unjustifiable risk. So did she know that there was a big risk that this could happen, and did she disregard that? And I submit to you that she did. And we know this by her own statement, which she changed because on scene, she said, "Oh, Mark Clanton jumped in front of my vehicle," indicating that she was looking forward. But when she talks to Detective Myers 11 days later, she changes her story saying, "Well, I was actually looking back." Ladies and gentlemen, we've all been to driver's ed or taken a state driver's course. Nobody is pulling forward while looking back. And we talked about multiple reckless driving behaviors in jury selection, which included not paying attention, being a distracted driver, failing to keep a proper lookout, failing to obey traffic laws, and failing to take proper evasive actions. All of those are present in this case. We talked about in jury selection how testimony is evidence, and so we're going to look at the witnesses that you heard from, starting with Officer Kyle Gabin. Ladies and gentlemen, it's no secret, he did not do his job on October 21st of 2023. He had been on the force for less than a month. You heard his own testimony that he took that call for training purposes, okay? He only made contact with the defendant and Mark Clanton. That was his responsibility as the reporting officer to go and find the witnesses. So that's something that should be counted against him. He did not speak with Aaron Rodriguez. And he made the wrong decision. And how do we know that? By the evidence. Mr. Clanton was never in the street at all. He was up on the sidewalk. Furthermore, you heard from 3 additional senior officers that Mark Clanton did nothing wrong on the offense day. Now, Officer De Leon was the first on scene. He handled passing the case off to the probationary officer. He separated the parties, and he did do his job correctly. He took statements from everyone that saw what happened, the defendant, Mark Clanton, and Aaron Rodriguez. And he also observed EMS treating Mark Clanton. Now, Aaron Rodriguez is probably the most important witness in this case because Mark Clanton is unable to be here today. But he observed the entire offense. And the account that he gave you from up there on the stand matches exactly the video evidence that we have in this case. He further testified that he heard the engine rev before the defendant took off. Ladies and gentlemen, that is evidence to her mental state at that time, which is intentionally knowing and at a minimum reckless. Aaron Rodriguez did testify that he saw the truck bounce up on top of that curb. Now, Detective Smith, you heard from him, and he testified that he received the report from Officer Gapin to conduct a follow-up investigation. And so he took many steps to conduct this investigation. He spoke with the defendant. He received State's Exhibit number 5 from the defendant. He reviewed it, and he deemed that the obstruction report was unfounded. And he believed that a different criminal act had occurred, and he referred it to the safe unit for additional follow-up.
Your objection, you never said anything about crime definitely occurring, said it might occur.
All right, ladies and gentlemen, you'll remember the evidence as you've received and remember the testimony of the witnesses. All right, you may proceed.
Thank you, Judge. You heard from Officer Sanchez. Now, he makes the scene. He interviews Mark Clanton. He observed the injury to Mark Clanton, and he wrote an assault supplement to be submitted to homicide for further investigation. And then we get to Detective Myers.
3 minutes.
You heard his testimony. He broke down the video for us, and you saw how Mark Clanton never entered the street and how that truck came up on the curb. He testified, you cannot use physical force, such as the defendant did with her motor vehicle, to get what you want. He testified that in his training and experience, a motor vehicle can be a deadly weapon, and he is the one that submitted this case against the defendant. Now, he takes this statement from the defendant, and as I stated before, she changed her story after she had 11 days to think about what she wanted her narrative to be, okay? And she gives little pieces. She says the entire thing is staged. I will let you all be the judge of that because you have State's Exhibit number 5. And she says Mark jumped in front of her truck. There's no evidence to support that. Her rendition of what happened is not supported by the evidence in this case. You also heard from Ina Clanton, who defense has the audacity to get up here and speak ill of her after her husband just died a couple of months ago, and she has to come up in this courtroom.
I have a problem with that. I didn't speak ill of her. I simply stated what she said on the witness stand.
All right, ladies and gentlemen, the objection will be sustained. You're just to disregard the last statement from the state. You may proceed.
Ina Clanton is in a predicament where she has to come in this courtroom after her husband has died months ago and identify him because of the actions of the defendant. And you saw the photos that she took of his injuries. And she testified that he was 78 years old on the date of the offense. Ladies and gentlemen, State's Exhibit number 4 is the only evidence that we have from the mouth of Mark Clanton. And I urge you to look at that evidence when you go back to the jury room. And what's in State's Exhibit number 4 is that Mark Clanton sustained right-sided knee pain from being hit by a vehicle and an abrasion. And you will see the photo that was entered into evidence as well. Now, you all, at this point, are just deciding whether the defendant is guilty or not of the offenses that she's been charged with in the indictment. You've been instructed that you cannot let bias, prejudice, or sympathy play into your deliberations. This is something that we talked about in jury selection. And so if you feel like, oh, you don't think she deserves jail time, or you feel sorry for her, or you think she has mental health issues, those are things that would be considered in punishment, okay? You all swore to do a true verdict according to the law and the evidence. And I want to talk to you further about what makes aggravated assault with a deadly weapon. It's
30
causing
seconds.
bodily injury using a deadly weapon. This truck is a deadly weapon. It's a heavy duty F-350. The lesser included in this case is not appropriate because the charge says that it is imminent danger, but the offense was completed. And that's what makes it an aggravated assault with a deadly weapon. Ladies and gentlemen, you didn't have an opportunity to hear from Mark because he's since passed away, but you need to render justice for him in this case. And the only verdict in this case that is appropriate is a guilty verdict. Thank you.
All right, ladies and gentlemen, I'm just going to have a couple of you remain. All right, we're on the record in 2024 CR 2675 State versus Darren Johnson. Could I have parties announced?
I think I'll wait for the state.
And Ms. Johnson, if you could come forward.
William Davidson for Miss Johnson and Robert Porter.
For the record, Ms. Johnson is present in court. The court has received the following question from the jurors. What is the meaning of gross by the law? Any objections to the following supplemental charge? With reference to your inquiry, you have all the evidence before you. Please continue your deliberations. Any objections, state?
No objection.
Any objection, defense?
No, Your Honor.
Any objection to the court sending the question, the answer to the jury?
No, Your Honor.
All right, thank you. All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct? And is that verdict unanimous? All right, if you'll hand the verdict form to Deputy Laura, please. All right, if defendant will please rise. Count 1, aggravated assault with a deadly weapon. It states, we the jury find the defendant Darren Johnson not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment. Count 1, the lesser included offense of misdemeanor deadly conduct. It states, we the jury find the defendant Darren Johnson not guilty of the lesser included offense of misdemeanor deadly conduct under count 1. Count 2, injury to an elderly individual. It states, we the jury find the defendant Darren Johnson not guilty of count 2. You may be seated. Does anyone wish to have the jury polled? All right, ladies and gentlemen, if you will go back to the jury room and I'll come and speak to you briefly. All right, everyone, please rise for the jurors.